Well, good morning. We are live from Minneapolis, Minnesota. Taking a look at the comments here today, that is where we will be getting a number of the questions presented by you related to business law. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. The purpose of this YouTube channel is to empower business owners with education and knowledge so you can avoid legal problems, improve the likelihood that you have a stronger company, and hopefully achieve a more successful life. All right, here we go. Here's the first question. Can you pay two LLC owners different amounts? So imagine two business owners start an LLC, and maybe one works as CEO and one is a software coder. And they might agree at one point they'll get paid the same amount. In fact, many times in the beginning, they don't get paid anything because the company hasn't made money yet. But as the company starts making money, the business owners want to get paid. And the question then is, can they get paid different amounts? The short answer is, if they agree, absolutely. If the business owners agree on what they'll each get paid, they can get paid different amounts. But what often happens is business owners don't agree. And so in that case, you have to look at a couple different things. First, you look at in the operating agreement of the LLC, is there anything that talks about how the owners will get paid or how profits will be divided? Usually, profits are divided, but that's after employees are paid. And if the owners are working in the company, the owners are getting a wage for working in the company or a salary or whatever that looks like. So it's quite common for owners to agree in the beginning they're both going to get paid the same amount. But then as their responsibilities are different, the owner with greater responsibilities believes he or she should get paid more. So what do you do about that? Well, it's important as far as the owners are concerned, they need to come to some agreement. The law basically says you can pay a fair market wage to each person. And so if the owners cannot come to an agreement, what do you do? Because obviously, if they can come to an agreement, fine, we don't have an issue. If they can't come to an agreement, the law generally says pay each individual a fair market wage for the work they're performing or the job responsibilities that they have. Okay, so that assumes there's no prior agreement. So if they didn't have any agreement in place, then we look to fair market wages for the particular position. Now that there's a special issue if a person can't maintain the position they were given and they're given less responsibility. And in most states, the law is you have to go out of your way to accommodate them to help them do the job that they originally given. And if that's simply not possible, then you need to accommodate them for the next available or next best type job that they actually can perform. This comes up a lot as people age and technology improves and changes. You can find that a senior business owner may struggle with the new technology implemented in the company. And the law basically says you need to get them an assistant who can help them with that technology or get them some training that can help. Okay, but going back to the issue now, how do you figure out what a fair market wage is for a person? Well, that's whatever would be paid in the marketplace if you hired a person to do that job. So, for example, if it's a 3-employee company and you need a manager with basic entry-level management skills because there are only 3 people and the manager is one of them, that's going to be a much lower fair market wage than if the company has 100 employees and needs a CEO to manage the entire organization. So you look at the job sites online to see what would a person get paid for that type of position. And of course, it's going to be a range. So for example, you might see a range of $70,000 to $100,000 for a particular position. Well, now you know that that's the range that you need to be in for that fair market compensation. Another way that you can handle this is hire an outside compensation expert to set the wage for each one of the owners who work in the company. That way, you are delegating to an expert who's objective and applying the law, and it is not a personal decision among the owners. So, that's another way that you can do that. All this stuff should be done with the advice of a good attorney. Next question. How do you find out legal regulations for your business? So here's the scenario. You started a new business. It's in a particular industry. It's in a specific niche. You Google, you can't quite find what laws apply to you. Because keep in mind, not only are you in a niche of an industry, but you are also in a specific country, state, county, city, etc. And each one of those layers of government have different laws. And this is an area of law called compliance law, sometimes called regulatory compliance, because not only do you have state statutes passed by the legislature, for example, but you may have regulations and rules implemented by a department of the government. In other words, the state legislature may have delegated the authority to a department in the state government to establish rules and regulations for a specific industry. So, what are you to do as a business owner? There's not an easy answer aside from contact an attorney in your area who works in this space and can advise you on this. I do that on a fairly regular basis with new clients who come aboard in my firm. But what are you supposed to do? Well, obviously Google, but that doesn't need to be said. Another option is to reach out to either an industry association or the government agency or department that handles this area. So let's say, for example, you are a hairstylist, and in your state or country, you have a hairstylist association. You can contact them to see if they have any guidance on rules, regulations, and laws related to your particular industry. Usually, associations won't tell you exactly what they are, but they'll point you in the right direction. They'll say, here are the government agencies and phone numbers or websites or online legal guides provided by the government for your particular industry or niche. Of course, then you can contact the government. And usually there isn't harm in doing that as long as you don't give too much information. So I would say, for example, contacting the state government and say, I am looking at being a hairstylist in, and then you'll name the city and the county and the state. Who would I contact to find out any rules and regulations or legal requirements for me? And typically, with a few phone calls, you can identify a department in the state that handles this, and they may even put you in touch with city or county authorities who can help you with this as well. So you're not saying, hey, I'm already offering these services. I'm trying to find out if I'm doing it legally, because you might be inviting an audit. But if you say, hey, I'm looking at business in this area. I want to ensure that I do everything right. Who can I contact for this? That would be a productive way to identify rules, regulations, and laws at every level of government specific to your industry and niche. Next question. If a will and power of attorney conflict, which one prevails? It's not possible for a will and a power of attorney to conflict. And here's why. A power of attorney applies during life as long as you have capacity, or I'm sorry, let me say that over again. A power of attorney applies during life. A will applies after you have died. So, because they are totally different time frames, they cannot conflict. A power of attorney has no authority after someone dies, and a will has no authority prior to someone dying. So, a will and a power of attorney cannot possibly conflict. Is an is an oral LLC ownership percentage enforceable if it's not in writing? So what do we have here? We have business owners, let's say two of them, and they agreed to a ownership percentage split of the LLC. Let's say it is 25% and 75%. But they never put it in writing. They never sign an operating agreement. They they simply didn't formalize any of this. You'd be surprised. This is actually quite common because business owners will start out agreeing to something and they say, you know what, once we get going, we'll put it in writing. And then they get busy and they have a lot of opportunity or they have problems and they're busy working on the business. And then finally they go, we better put that in writing. And usually that comes up when there are some other problems. And I can't tell you how many times I've seen people have a different viewpoint on what the ownership percentage should be after they've been running the business for a while. I have seen many, many times where owners will start out with a one percentage and then one owner wants to change it or argues that it should have been a different way or the I saw one time where one owner said, I said you could get 50% if you did X, Y, and Z, or if we achieved certain milestones. And the other business owner said, no, that wasn't my understanding. My understanding was I get 50%, and then we'd work together to achieve those milestones. So, as you can see, this can be messy. Is an oral agreement enforceable? Absolutely. In virtually all states, if not all of them, an oral agreement is enforceable related to the ownership percentage of a business started between two partners. It doesn't matter if it's an LLC, it doesn't matter if it's a corporation. If the owners agree on a percentage at the time they're or before they start the business, at the time they start the business, or at any other time after that, that oral agreement is enforceable. Now, proving it is a whole nother issue. How do you prove that? Well, maybe there are some emails, maybe there's some tax returns, uh, maybe there's a recording of some sort, maybe there's a witness of conversations that occurred. Maybe the witness didn't observe the two business owners talking about this issue, but the owners went home and talked to their spouses, and the spouse is at least a witness to what the business owner understood was the arrangement. And then finally, even if you don't have any of that, in litigation, you can do a deposition. A deposition is where you ask the other party some questions. And it may be that a judge or jury finds one party more credible, trustworthy, and honest than the other party. And so ultimately, you can, um, it is very common that you can prove an oral agreement through other sorts of evidence. But even if you have no evidence at all, legally, an oral agreement for ownership percentage of a business is fully enforceable. Next question. How does the IRS see an LLC? This is a big area of confusion for people because for most of the law, an LLC is a separate entity from you. That's the whole benefit of an LLC. LLC stands for Limited Liability Company. So by being a separate company, it's a separate individual under the law. And because it has limited liability, that means you're not personally liable. But how does the IRS see it? The default rules for an LLC. So unless you change something, your LLC is seen as a sole proprietorship by the IRS. That's if you have one owner of the business. If you have more than one owner, the IRS sees it as a partnership. A sole proprietorship and a partnership is the default tax treatment if you didn't even have an LLC. So the IRS does not recognize really the LLC. It is called a pass through entity. The IRS sees right through the LLC and treats your business as owned by you, either as a sole proprietor or a partner. Partner in the case of multiple business owners. So just to recap, let's say you have a LLC with 5 business owners. The IRS will look at you as a partnership with 5 partners, and you divide the profits among 5 partners. You might be wondering, what about an S corp? S corp is a different tax treatment. If an LLC wants, it can elect to be taxed as an S corp. So you can have your LLC taxed as an S corporation. And in that case, the corporation will have its own tax return. If your LLC is a pass-through entity, do you lose limited liability? No, you don't. The term pass-through entity applies to how the IRS taxes you. It doesn't mean you are just passing everything through the LLC to yourself for other legal purposes. It's only a tax analysis. So when an LLC is taxed as a partnership or a sole proprietorship, which are the defaults for an LLC, the IRS considers that LLC a pass-through entity. But for all other legal purposes, the LLC is considered a separate individual under the law. And you have a limited liability shield between the LLC and you. So you as the owner are not personally liable for the activities of the LLC. There are exceptions to this. It's called piercing the corporate limited liability shield or piercing the veil. So piercing the veil is the term usually used for corporations. Piercing the limited liability shield is what's usually used for LLCs. But the piercing the veil doctrine essentially says there are some exceptions for when a business owner can be personally liable for the acts of the LLC. If you're interested in learning more about that, feel free to add comments below. I'd be happy to do a video on piercing the veil. Can I use a registered agent for my bank account address? The bank requires a utility bill as proof. So what's happening here? A business owner has an LLC, let's say. Maybe it's a corporation, maybe it's a sole proprietorship, but for simplicity's sake, we'll just say it's an LLC. And the LLC is using a registered agent. What's a registered agent? A registered agent is a physical office address where the LLC can receive lawsuit documents and perhaps mail and other correspondence that's sent to them. You typically pay a company to use a registered agent service. It could be anywhere from $100 a year to $1,000 a year, depending on the services that you want available there. So the question then is, can you use that registered agent service for your bank address? The answer is yes, you can, as long as the bank will let you. But legally, there's nothing wrong with using a registered agent service to collect all mail and other correspondence sent to you, which then gets forwarded to you. Sometimes this is called a virtual office. It's very common. But a bank has a right to make their own rules and policies. They're a business like anyone else. They're able to set up their own requirements. And so if they require a utility bill as proof of an address, then that bank may not allow you to use your registered agent service as the address on your bank account. For example, on your checks. If I were in your situation, though, I would try to talk to more of a senior banker and explain to the senior banker, I have a registered agent service. Here's proof of the registration for the LLC with the state under that address. Here's proof of my registration with the registrations or the registered agent service. If it works for the state, it should work for the bank. Is there any way we can get approval for this? If the bank says no, you need a utility bill to prove it. Well, then I might look at changing the utility bill. Just see if you can temporarily have a utility bill sent to your registered agent service so that you can get that bill and bring it into the bank. So that would be a creative workaround if you run into a bank that is feisty. You might also just look for a different business bank because, in my experience, good business bankers aren't hung up on little technicalities like utility bills. They can take a look at a state business registration and a registered agent contract to and understand that for all other legal purposes, you're paying to use somebody else's address and all correspondence gets to you. There's no reason the bank or anyone else shouldn't be willing to use that registered agent address for your business. All right, let's take a look at this next question here. Are you responsible for paying quarterly estimated taxes as a single member LLC? Or can you just pay them when you file your tax return? This is a great question for a CPA because CPAs work closely with the IRS and any changes in requirements. What you probably know is that an S corporation must report and pay taxes on a quarterly basis. But the last time I checked, an LLC can wait until the end of the year to pay its estimated taxes, at least in the first year. Now, depending on the circumstances of the LLC, there may be some requirements to make estimated payments. I would talk with a CPA in your jurisdiction about what the requirements are for you. My understanding is that if you are expecting substantially higher income next year, you would have some obligations to pay. If you know what, I won't even go into all the exceptions, but I would say it's a great idea to work with a CPA in your area. I have found that a CPA's expense is far less than the benefit and the tax savings available to me by using the CPA. In my experience, the CPA has saved me far more than 10 times what the fees are that I've paid to the CPA because the laws keep changing for tax breaks. We had economic stimulus packages, we had COVID packages, we had all sorts of special COVID um, forgivable loans, PPP, etc. There have been so many changes in the law that as a tax attorney, I can't even keep up with all these changes. It takes a CPA who just lives in the world of tax law, who can figure out changes each year and then communicate those to their clients when doing the tax returns. So I always recommend for small business owners, use a CPA. There's one other important reason that you should use a CPA for your tax returns. It can provide you some protection under the law if things are done wrong. Here's why. If you do your own taxes and you're not relying on the advice of a CPA and you do things wrong, you can be liable for tax fraud. But if you relied on the advice of a professional, a licensed professional like a CPA, that is a legal defense to tax fraud. You have every right to rely on the advice of a licensed CPA or licensed attorney when doing tax returns. And so if you do that, you cannot leave, generally speaking, you will not be liable for tax fraud. Now, there might be some extreme situations where it was really clear you were doing something wrong, but it is a very valuable defense to tax fraud if you relied on the advice of a licensed professional like a CPA or attorney. That's an important reason why business owners should not do their own taxes, should not just pay a tax preparation service or an enrolled agent. You should use a licensed CPA to do your taxes. Next question. Do you need a DBA for multiple online businesses? This was a comment on one of our YouTube videos, and a little bit more information was provided by the viewer. It says, physical products will never enter my state, and I don't have a storefront. So, do you need a DBA for multiple online businesses? I think there's a misunderstanding here because you never need a DBA for legal purposes. A DBA, which stands for doing business as, is just a nickname for your business if you want to use it for marketing or branding purposes. So, example, if you opened uh, Sally's Bakery LLC and then Sally went into catering as well, Sally might set up a DBA that says Sally's Catering. So she would still have Sally's Bakery LLC, but it is also known as, because of the DBA, Sally's Catering. So you do a DBA for marketing purposes. You do not need legally a DBA for any other reason. You're only using that an alias or a nickname or a DBA if you want to be known as something different from your LLC. Keep in mind that a DBA is not a separate business entity. It's not a separate LLC or anything else. It's a nickname. Just like I might go by Aaron, Dad, or Bro. Regardless of what people call me, I'm one person. That's how a DBA works. Regardless of how many names an LLC has, it's just one LLC. An LLC might have 100 nicknames. In other words, 100 DBAs. It's still one LLC. So let's go back to the question. Do you need a DBA for multiple online businesses? The answer is no, but here's what I think the person asking the question is getting at. Do you need a registered agent for multiple online businesses? In other words, do you need a physical office address in each state where you are doing business? Generally, the law says yes, if you are doing business in a particular state, you need to register in that state. It's called a foreign entity filing. So if your LLC is located in Minnesota and you are doing business of any type in New York, you need to register in the state of New York in the Department of State Government that handles LLC registrations. You don't set up a new LLC. You register your Minnesota LLC as a foreign entity doing business in New York. You might say, well, if I'm selling to all 50 states, that's expensive. I'll have to register in all 50 states. That's true. Unfortunately, that's what the law says. And what you might say, well, what happens if I don't? If you don't, you may not know if you get sued in that state. Because in most states, when somebody sues you, they can serve it on the state department that handles business registrations. And if you're not registered there, you'll never get the documents. If you don't get the documents, you can't respond to the lawsuit. If you don't respond to the lawsuit, you lose that lawsuit. And then what happens? The person who won the lawsuit against you can start garnishing your bank accounts in any state. So if you don't register in each state, you will risk losing a lawsuit that you never knew about. And in order to register in most states, you need a physical office address. And obviously, you don't want to rent an office in every single state. So, what you do is you pay a registered agent service. Registered agent services are companies that have a physical office located in all different states. And you can pay for that address. So, like, for example, if you have a California registered agent and you're doing business in California, you will first set up the registered agent service in California. So now you have a physical office there where if you get served a lawsuit, it will be delivered to you. And then you go register with the state of California as a foreign entity, so like LLC or corporation, doing business in California. That is typically the process to ensure that you are in compliance with the law and you know about every lawsuit that may get served upon you because you have registration in every state where you're doing business. Here's a similar question. When are you required to use a DBA? For multiple product lines, multiple industries, multiple office locations? Here's the answer. You are never required to use a DBA. You can use your same company name instead of using a DBA. People choose to use DBAs for marketing purposes. DBA stands for doing business as. A DBA is sometimes known as a nickname, an alias, an assumed name. It goes by a lot of different names, but the idea is it's a separate name for a single LLC or corporation or sole proprietorship or partnership, I suppose. So you don't need a DBA for any reason that's legal. The only reason you might use a DBA is for marketing purposes, because for whatever reason, your business name as it exists is not working for a particular industry or target market. How does a no win, no lawyer fee work? When people hire lawyers on a contingency basis, it's sometimes known as no win, no fee. In other words, you might have seen this on late night television commercials. The lawyer says, if we don't win or if we don't recover for you, we don't get paid. If we don't get money for you, There's no money for us. No lawyer fees for you unless we recover. So, how does this work? You sign an agreement with a lawyer that says whatever amount the lawyer recovers, you'll get, or you will pay a portion of that, a percentage typically, to the lawyer. And the remainder goes to you. Now, you'll also want to take a look at whether expenses come off of that. So, expenses might be court filing fees, mailing costs, copier costs, things like that. Usually, how this works is the lawyer's agreement says, like, let's say you get in a car accident and you have $10,000 in medical bills, a a loss of your $30,000 vehicle, and let's also say that that after the lawyer works for you, the lawyer gets reimbursement of all your medical bills, the $30,000 for your vehicle, plus, let's say, $15,000 for pain and suffering. In other words, all the pain that you went through, etc. How does that get divided up? Well, it depends on the agreement you signed. In my experience, the agreements have said first, you get an amount to cover your medical expenses. That's not going to be, the lawyer's not going to take a cut of that. Second, you get an amount to cover your vehicle. The lawyer's not going to take a cut of that. What the lawyer does get a cut of is the pain and suffering portion after your out of pocket costs are covered. But that's not always the case. And so it's very important to take a look at the representation agreement or service agreement or whatever the lawyer calls the contract that you sign. You might even want to have a second lawyer take a look at this if you're having trouble understanding it. And they're not always clear. So I think it's very reasonable to share the pain and suffering fees with the lawyer. But I would recommend that to the extent you had any out of pocket costs for medical expenses or car purchasing a new car, I'd recommend you find a lawyer who isn't going to get a piece of that. Because if you had a $30,000 car and $10,000 in medical expenses, and now the lawyer is getting a third of that, you're not going to have enough money to cover your medical bills. You're not going to have enough money to buy the same car you had. So it's very customary for the lawyer to get a percentage of the pain and suffering portion, or the portion after your actual costs are covered. But I would carefully look at your agreement to make sure you're not dividing the rest. What's a reasonable percentage? The most common percentage is 1/3 that the lawyer gets. But I've seen anywhere from 20% to 50%. And that very much depends on how difficult the case is and whether the lawyer is willing to take that. So that's how a no win, no fee works with lawyers. It's lawyers often call it a contingency fee. And if you are having problems with this, I'd recommend you either contact a lawyer in your state or the state agency that oversees lawyers to get clarification on how something like this works and what your rights are. When can a lawyer fire you? So you're the client, you've hired a lawyer. Can the lawyer fire you? A lawyer certainly can fire you. But it will depend on two things: the rules within the representation agreement, so the contract provisions within the agreement that you sign with the lawyer, and the law. For example, the contract probably says something like, at any time, the lawyer can discontinue services for you. The lawyer is still entitled to payment through that date, but the lawyer can terminate services for any reason permitted by law, and within the restrictions allowed by law. So then we go to law and say, what does the law say? Well, most states have a law that says a lawyer cannot quit right before something really big and where you don't have time to hire another lawyer. So, say for example, it's a day before trial and the trial looks like it's going to take 10 days. And the lawyer decides, you know what, I just don't want to put in the work for this. I did this case on a contingency basis and I don't want to give up 10 days of work. We're not going to recover enough. Can the lawyer quit and just fire you and say you're on your own? Most states say no, absolutely not. Now, if it's a few weeks before trial and you would have time to hire another lawyer and that lawyer get up to speed and get ready for trial, that may be reasonable. There isn't a cut and dry line like a certain number of days prior to a hearing or a trial that a lawyer can terminate a client. It all depends on the circumstances. And in general, the rule is there enough time for the client to hire another attorney and get them up to speed? Now, the client might say, I can't find another attorney because they'll want more money and I'm out of money. Well, that usually is not a consideration. The question is hypothetically, could an attorney get up to speed in time? If the client can't afford to hire an attorney or won't pay, you can't force an attorney to work for free. So, usually, what's important is there enough time for the client to hire another attorney? If so, then the attorney can terminate services for any reason permitted by the attorney's contract with the client. Can a business DBA help with SEO? This is actually a pretty creative idea. If you want to set up a business in Google Maps, for example, or Yelp, you might want to use certain keywords that work well for SEO. SEO stands for search engine optimization. In other words, if people are typing in keywords into Google or Yelp or some other platform, and you want to come up first for those keywords, you may want to register those keywords in your profile name. But for example, Google Maps says you can't use keywords in your profile name. You must use your legal business name. So then the question is, can you set up a DBA with those keywords? You absolutely can. As long as you put those keywords in your DBA, you now have a legal business name with the keywords. So, what's an example here? Um, let's say I'll just pick a simple one. Probably would never do this, but cheap plumber. So, let's say Al's Plumbing Incorporated wants to be listed in Google Maps as cheap plumber. Al goes and checks with the state and sees that nobody else is using cheap plumber as a DBA or assumed name. So Al registers cheap plumber as a DBA with his state. Now, as long as Al has fulfilled the requirements of using that name legally in the state, Al can use that state registration to show Google that he has a right to list the business as cheap plumber. And I've actually seen this before. And as long as you can prove state registration information to Google, Google allows it. So, yes, you absolutely can use a business DBA to help with search engine optimization. Can you use special characters in a DBA? So, special characters might be a question mark, exclamation mark, hyphen, tilde, colon, period, comma, any sort of punctuation marks. Generally, each state has specific rules about what punctuation will be permitted. So, your best bet is to check with your specific state. In my experience, a few punctuation marks are permitted, but most are not. And this comes up with numerical characters like the number 1, the number 7. Um, Usually numbers are permitted, but most punctuation is prohibited in my experience with state governments and their rules regarding naming businesses. How does the IRS see a DBA? This is a question by Susan Johnson. It was a comment on one of the YouTube videos, and she provides this additional information. We currently have two DBAs, one for 20 years, one less than a year. We're trying to decide whether to set up one or two LLCs. The businesses are similar, design and advertising, but they have different clients and different products. For example, one is on the web, one is in paper. We're thinking to set up one with an account in a new bank, but keep one bank account, the newest venture, in the old bank in case people wrote us checks to that name, to be less confusing since we launched that name. We're thinking to then transfer those funds to the old account. Is this a good idea? Does it create any liability hole? How does the IRS see it? All right, a lot of issues here. How does the IRS see a DBA? The IRS ignores it. They don't care. It's kind of like if I go by Bob or Robert, does the IRS care? No. It's just DBAs are different names. The IRS looks right through those DBAs to say what is the legal entity underneath. So the IRS ignores DBAs. I have a separate video talking about how to use DBAs and the use of them for marketing purposes. So I'm not going to go into that right now as far as what's better for particular clients or industries, etc. The bottom line is you don't have to use a DBA for legal purposes. It would only be for a marketing purpose. Let's talk about banks though, because you can use a DBA to set up a bank account. And even though a DBA is just a nickname, sometimes business owners decide they want to have one business account for a DBA and another bank account for another DBA. You have every right to do that, but legally, those are just bank accounts for the underlying company. DBAs are not separate entities. They're nicknames for the underlying company. So you can have as many bank accounts as you want, and you can have different DBA names on those bank accounts. But at the end of the day, it's just company money in different bank accounts. Just remember, DBAs are nicknames. The way the IRS and the law looks at a DBA is they look right through it to say what is the company that and what does it own. Okay, I have another question here. If you have a virtual business with no physical location, are you still responsible for registering as a foreign entity in any state your client resides? Yes, you are. Let me tell you a story. There was there was a company not with no presence in Minnesota except some employees who did cleaning here. The employees quit and sued the company for discrimination. The company had not registered in Minnesota. The company was registered in another state. And because the company had not registered in Minnesota, when the employees sued the company didn't know about it. So the company didn't respond to the lawsuit. And then, because the company didn't respond to the lawsuit, they lost the lawsuit. Once that lawsuit was lost, the employees, with their attorney, transferred the judgment from Minnesota to the state where the company was located and had a bank account. And then they froze the funds in that bank account. It was a very large amount of money because keep in mind, the employees essentially got whatever they asked for in the original lawsuit because the company wasn't there to defend itself. So the company gets notice that its funds are frozen with the bank. This is called a garnishment. And then the company reached out to me and said, "We never knew about this lawsuit. We were never served. We have a constitutional right to get some sort of notice or get served." And I made all those arguments to the court. There is a law in Minnesota that permits you to reopen a case under certain circumstances. But what the judge said in this case was the company didn't do what it was lawfully required to do: register as a foreign entity in the state of Minnesota if you do business here. Because they didn't, and if they had done that, they would have known about the lawsuit. So they didn't do what they were supposed to do, which means the judge is not going to open this lawsuit. As a result, the company was stuck with the outcome of a lawsuit that they never fought because they never knew about it. So if you are doing business in a state where you have employees or you have customers or clients or any other activity, if you want to know about lawsuits against you in that state, you need to register as a foreign entity in that state. If you don't do that, you take the risk of getting sued. Now, you might say, what if I'm comfortable with that risk? A lot of companies are. And often, if there's a dispute with a customer or client, you know about it. And so, and you might even get served the lawsuit at your address. They may not serve it at the state government office. But that's a risk you take if you are not registered to do business in that state. It doesn't matter where you have a virtual address. It doesn't even matter if you've paid for a registered agent service in that state. You need to do the second step, which is registering as a foreign entity with the state government for that state. Should an insurance policy be under your name, LLC, or DBA? And I see that this is a question from a nurse. All right, first off, a DBA is essentially ignored. It's just a nickname. So there's no real reason to have an insurance policy under a DBA. But now the question is, do you have it under your LLC or your own individual name? To answer that question, it helps to understand what is an insurance policy. I know we all know what it is basically, but from a legal standpoint, an insurance policy is a contract that says if you are liable for something, somebody else will take over that liability, the insurance company. So the question then is, do you want the insurance company to take over liability for your LLC or for you individually? Now, many times you can get it for both, and that's going to be best for you. You might have an insurance policy under your name, but your LLC is a named insured. So, in other words, we have named your LLC as also insured. The technical language for that in the insurance industry is the named insured. So, the parties insured under the policy are going to be you and the LLC. That's going to be best. If you must pick between the LLC and you individually, then I would say who's more likely to get sued? Because you want to have your insurance policy where the lawsuits are going to be. And if the LLC has virtually no assets in it, like for example, if a nurse is just providing services through the LLC, I wouldn't be too worried about that LLC getting sued because the nurse could just shut down that LLC. It has no assets, and the lawsuit essentially dies with the LLC. So in that case, I'd say have the insurance policy with the nurse. Ideally, you have both, but if you must pick, have it with the individual nurse. But this would be very different if the LLC has equipment or real estate or other valuable assets in it. You will want that LLC protected, and you'll probably want to be protected yourself. So even if it costs you a little more to get protection for both the LLC and you, that is what I would negotiate with the insurance provider. Sometimes insurance companies do not charge extra to have an additional named insured for these types of claims. Sometimes they charge a little bit extra. Sometimes you have to have an entirely separate policy. It's all a contract with the insurance company, so rates are open to negotiation. That's not to say insurance companies are willing to negotiate their rates, but in theory, at least, you can get different rates from different insurance companies. So you might check around and see if you can get both your LLC and yourself insured on a policy. Is a voice, excuse me, let me have a quick drink here and I'll read this next question. Is a voice recording enough to prove an oral contract? So imagine you have two parties. They talk about an agreement. They say, hey, I'll give you a simple example. Um, I'll pay you $100 to paint my fence. And the painter says, sure, that sounds great. The painter shows up to paint the fence that morning, and the homeowner says, I changed my mind. I don't want you to do it. That was an oral contract because the owner said, I'll pay you $100 to paint my fence. And the painter said, sure. The owner is technically breaching that contract by trying to back out of it now and saying, hey, I changed my mind. But it was oral, it wasn't in writing, it was spoken, not on paper, not in email. Is a voice recording enough to prove an oral contract? Yes. All sorts of evidence can be used to prove that an oral contract exists. You can use paper, email, testimony of someone else, a diary, a journal. Uh, there are all sorts of ways to present evidence in court to prove that an oral contract existed. And an oral contract is usually just as enforceable as a written contract. There are a few exceptions to that. It's called the statute of frauds. For example, transactions in real estate need to be in writing under the statute of frauds. Um, but if the other side, there are some exceptions to the statute of frauds. For example, if the other side admits that there was a contract in place, even if it was oral, that is usually an exception to the statute of frauds. And there are other exceptions. Can you enforce a contract with no evidence at all? You sure can. Contracts are enforceable even if you don't have a copy of the contract and you don't have any evidence at all. Now, ultimately, you will have to somehow present evidence in court, but that evidence can be your oral testimony. It could be the testimony of other witnesses. So even if you don't have evidence now, you can create evidence of an oral contract prior to actually having a trial in a court. So, do you actually need evidence to win a case in court? Yes. Ultimately, to win a case, you'll have to have evidence, but you don't need that evidence at the start of the case. You just need to have evidence, such as your own testimony, before the trial is over. My employee used his software code in our company. Who owns the code now? This has become an issue. A number of companies have had employees use their own code in some company software. And what I mean by the employee's own code is it may have been written by the employee prior to coming into the company. So who owns the code now? Did the employee freely give it to the company and now the company owns it? Or does the employee still own it? And can the employee tell the company, you have to stop using my code if the employee is no longer at the company? Here's how this works. It's, by the way, it's a copyright analysis. So this is all under copyright law. When the employee first wrote the code, the employee acquired copyright ownership in the code. So the employee has intellectual property rights, the right of ownership of the code. Unless the employee transfers that ownership, the employee keeps it. So let's say the employee uses the code in the company's software. That use is called a license. So the employee is allowing the company to use the code. That's called a copyright license. License just means permission to use. So now the company has a right to use it, but it doesn't mean the copyright or the company owns the code. So let's say the employee gets fired, and now the employee says, hey, by the way, you have to stop using my code, which is somewhere in the company's software. Does the company have to? Well, first off, the company doesn't own the code. The employee owned it because the employee created that code before joining the company. So the copyright is owned by the employee, but the employee allowed the company to use it. It's what is called an implied license. By putting the code in the company's software, the employee was performing acts that imply the employee was authorizing use of the code. So the company has a license to use it, but for how long? That is now a difficult issue because the employee is going to say only as long as the code or the company only has a right to use the code as long as the employee is working in the company. The company is going to say we have a right to perpetually use this code because the employee was hired to make the software work. We didn't even know the employee used this code, or maybe they did, but either way, the employee was fulfilling job responsibilities by making the code work. It would be sabotage to allow the employee to pull that code out now, leaving the company's software disabled. Ultimately, I think the company would be likely to prevail if this went to court. In other words, I think a judge would be likely to say the employee does not have a right to withdraw the license for the copyright just because the employee got fired or they got fired. It'd be a different story if the employee had in writing that the company can use the code as long as the employee is working there. That's a different scenario. But if it was never discussed, I believe a court is likely to conclude that the employee authorized ongoing use of the code by putting it in the company's software, and the employee does not have a right to stop the company from using that code now that the employee is terminated. As you can see, this is messy, and all parties would be better off if they had something in writing. And so, whenever an employee is using their own code or phone or computer or laptop or creative work or data, anything that the employee is using that's personal, it makes sense to sit and think about, should we have an agreement in place about what happens when the employee is no longer here? For example, if the employee is using her phone and she leaves, what happens to the company's code, email, or data on that phone? Here's a similar question. My employee used company resources to create a new business idea. Who owns it? The general rule is that if company resources are used to create a business idea, the company owns it. Those resources include company time, company computers, etc. If an employee creates an idea on his or her own time, then the question is the business idea related to the company? And if so, the employee probably had a responsibility to present the idea first to the company for the company to take advantage of. That's called the fiduciary duty of loyalty, which employees owe their companies. If the company said, no, we don't want to pursue that, the employee could pursue it in their own time, and the employee would own that idea and the intellectual property rights around it. But if the employee is pursuing an idea that the company that relates to the business of the company, that employee is risking the company coming back later saying, you never presented that idea to us. And so we now own that idea. And if the company sues, the company could seek disgorgement. I have another video on that. But disgorgement of profits basically says if the employee starts some new company and it's really profitable, the employer could take all of the profits from the new company because it came from an idea that should have belonged to the company or at least presented to the company first. So my advice to employees is if you're going to pursue something in your own time, either make sure it's clearly outside the scope of the company and what they do, or if it's similar, consider presenting the idea to the company. And once they decline it, then you're authorized to go do this on your own. And you're clear from, as long as you're not using company resources, that's your own separate side gig. You'll own the intellectual property rights and the profit from that side gig. Can one business partner lock the other out of a bank account? It is quite frustrating when, for business partners, to have a breakdown in trust and in the relationship. And often I've seen when trust between business partners breaks down, one of them cuts the other off from the bank account. And the question then is that proper? Well, the one cutting off the other often says, I cut them off because I didn't want them to do something improper with the bank funds. And then the business owner who gets cut off is angry and says, I don't trust what the other person is doing. I've always had access. I've never done anything wrong. Uh, I believe the other business owner is doing something nefarious or selfish, and that's why I've been cut off. Here's what the law says. Business owners have a right to all of the important financial information in the company, both business owners. So you have a right to that information. But that doesn't mean a right to transfer funds in the account. If a business owner's job or performance of the business requires transactions in the account, then it is improper to shut off that business owner from making those transactions because you would be preventing the business owner from carrying out the duties of the business. But let's say, for example, a business owner contacted the bank and said, the other business owner never needs to make transactions in the account. I want their account to be read only so they can access information, but they can't make transactions. And maybe you take away their rights to sign checks. As long as that doesn't interfere with the business, that would not be illegal. It would not be a breach of fiduciary duty unless there is some contract that said otherwise. In other words, if the business owners had a contract that said they both have a right to the bank account, of course, you can't breach that contract. But we're assuming there is no contract for something like this. It's generally a bad idea to just blindside a business owner and lock them out. The only time I've recommended that is when there is evidence of embezzlement. And I tell business owners, not only do you have a right to prevent the other business owner from stealing money, you have a fiduciary duty, an obligation to protect the business and prevent theft from the company. Um, but you want to be very careful about that. And typically, I advise the business owner, once you do the lockout, explain to the other business owner what's happening here. And because they're probably going to lawyer up right away, they're going to be very upset, and you might have a lawsuit on your hands quickly. And some skills in diplomacy and diffusing the situation will be very valuable when you are selecting attorneys at that point. Let's take a look at the next question here. Can an employee sue a company for using the employee's code in the company's software? If the employee put the software in the company, or let me back up. If the employee put her code into the company software, and then let's say the employee is fired, can she sue the company? For example, could she sue for compensation for the continued use of the software? She definitely could sue. Whether she could win is another analysis. Here's why. I believe an employee could make a reasonable argument, which goes like this. While I was working in the company, I was being compensated through wages, so I didn't mind my software being used without any additional compensation to me. But in light of the fact the company has fired me and the company wants to continue to use my software code, which I own the copyright to, I'm entitled to reasonable license fees. The company does not have a right to use my software code for 100 years when I am no longer receiving any benefit from that. So that is a very reasonable argument, which could get you into court. And so you have every right to sue over that. But then the question is, would you win? Well, the company is going to argue that maybe they didn't even know about it and you should have disclosed it. But now they're relying on it. It probably doesn't have much worth anyway, is what they would argue. They'll argue you were being paid to write the code for the company. The fact that you use your own code was actually a violation of your duties. You should have written code, or at least you should have used code that the company could use indefinitely. It was improper of you to use code that was subject to copyright and would incur license fees to the company for the future. The company would argue that they already paid you a reasonable wage. They never agreed to license fees. And to the extent that you replaced your own services with code that you had previously written was on you. The company should not now be subject to ongoing license fees for code they never even knew about and code they never agreed to. You should have used code that was not subject to license fees. Who wins in this case? I think it's a tough one. Honestly, it could go both ways. I think there's a higher likelihood of the company winning with the facts I've presented here, but it very much is going to depend on the circumstances. I also think the value of the code is going to matter. For example, if it's a small amount of code that would have taken 5 hours to write, I don't think the employee is going to get any compensation for that. But if the employee spent 20 years writing this code, or that's probably unrealistic, but let's say 5 years writing the code before joining the company, uh, and it's a significant portion of the company's code, I think a judge will look at that and go, you know what, the employee deserves some compensation. Um, yeah, the employee probably did wrong. Shouldn't have used that code without author telling the company. But there's no way, I think the judge will say there's no way that the employee could have just written this on company time and wages would have adequately compensated the employee. The employee used years worth of code, and equity dictates or justice dictates that a person who does this work should be compensated for it. So, in summary, it could go either way. It will very much depend on the circumstances, but without, if I had to guess, I would say the company is likely to win unless there are extraordinary circumstances. What do you do if you discover employee theft? Well, one question is, did the employee steal from the company, your clients, or some third party? This is an issue that conjures up a lot of emotions for me because I one time had an employee come report to me that he had uh, misappropriated $40,000 of client money. So I'll tell you what I did. Step number one, I called up a CPA. Well, first off, I told the employee, you need to put that money back immediately, today, the full amount. I then called a CPA and said, I need you to review all my financials. I need to see if there was other theft. Because sometimes when people confess something, they confess only a portion of their misdeeds. I was concerned that this might be like an iceberg where I see the tip and there's a lot more underneath. So I called a CPA and asked the CPA to carefully scrutinize first all of our client money, and then second, any other large transactions in the company, especially related to this employee. Second, I contacted an attorney and I said, what is my responsibility here? You might say, why did you contact an attorney when you are an attorney? And I deal with this area on a regular basis because I was not objective and enough removed from the situation to think clearly about it. I needed an attorney outside the situation to say, here are the steps you need to deal with. At the time, I was dealing with a lot of emotions of betrayal and anger and frustration and remorse. I was wondering, how did this happen? What did I do wrong? How who could do this sort of thing? It was emotionally very difficult and psychologically very difficult to process. And I needed an attorney outside the situation to give me objective advice. I also I also wanted the protection that comes from relying on the advice of an attorney because If later somebody accused me of handling this in a wrong way, if I sought legal counsel and relied on the advice of that attorney, I have protection under the law that I tried to do what was right. So reaching out to an attorney can provide important protection and demonstrate that you are not being negligent in your duties. Um, by getting legal counsel and counsel from my CPA, I then was able to assess the situation and follow up. And in my circumstances, I was advised that I needed to report the misappropriation to the ethics board, which handles attorney misconduct and misappropriation of client funds. So I then did, in fact, do that. Your responsibilities may be different. Let's say, for example, you are the owner of a bank. You will have different government agencies that you may need to report this to. You also probably want to report it to your insurance carrier right away. And that's because in order to have protection under your insurance policy, you will want to have, or your policy typically requires prompt notice to the insurance carrier. If you discover somebody has stolen from you or your company or some sort of third party, the best advice I can give you is work with your CPA and lawyer to carefully analyze the circumstances that you're dealing with and make a checklist of what you need to do to properly inform any government agencies or third parties and to mitigate any harm that might come from this. Of course, the small amount of theft that you know about may may be a signal that there's more out there, and so it takes some extraordinary due diligence to prevent further harm and further theft. Do you fire the employee? Most likely, yeah. But do that with the advice of legal counsel. And usually you want to be very careful about that. In my case, I didn't fire the employee immediately because I was concerned that the employee would um, destroy evidence or take information with him that I needed to get first. So another thing I did is I immediately contacted our tech support company and had them make a backup of his computer and figure out how are we going to get his cell phone so that we can preserve that for evidence. So there's a lot to think about when dealing with employee theft, especially if it deals with a large amount or a theft from a client or somebody else's money who is in your care. Let's make this the final question. What can you do if somebody defames you without saying your name, but hinting at who you are? So, have you ever seen this before where there's defamation and it's very clear who they're talking about, but they didn't name the person specifically? Is that defamation? The law says if a reasonable person could read something and know who it's talking about, it's defamation, assuming it fulfills all the other requirements of defamation. It doesn't matter if a person is specifically named. So, as long as there is enough information for a reasonable person with knowledge about the situation, so not some random stranger, but others who are reading it, if any of the other readers could reasonably figure out who this is talking about, uh, it is not necessary that the statements specifically identify a person for the statements to be considered defamation. What is defamation? It is a false statement of fact about a person or company, and that false statement has a likelihood to harm their reputation or lower them in the esteem of the listeners or viewers or the public. I'll give you an example. Let's say somebody says, I have reason to believe that a hockey coach in our community is sexually or has sexually abused two children who are players on his team. Now let's assume, or is that enough to identify? And by the way, let's assume it's false. So clearly it's a false statement of the type that would harm someone's reputation. The question is, by saying a hockey coach in our community, is that specific enough to identify who that person is? Well, the judge or jury is just going to say, would a reasonable person who's seeing that statement be able to figure out who it's likely referring to? If there are only two coaches in the community, that's going to be more likely considered defamation and identity of who that person is. If you have children and they all, or let's say you have a child playing hockey, there may be an assumption that it's the coach on your child's team. If there have been rumors about a hockey coach and improprieties, a reasonable person may assume you're talking about that person. If you are putting that comment on a thread talking about a specific hockey coach, and then you throw it on there in context, a reasonable person could assume you're talking about that hockey coach. So as you can see, it's very much going to depend on the facts and circumstances. A judge or jury will take a look at that and say, would a reasonable person conclude that it's most likely this particular individual? And if so, that's sufficient enough to identify them, and thus it would be a defamatory statement. All right, that wraps it up for our questions today. If you have other questions, put them in the comments below. If you'd like to be notified next time about this live Q&A session, feel free to subscribe to this channel and turn on notifications. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. You can learn more about me at aaronhall.com. And if you'd like to sign up for our free resources, go to aaronhall.com/free. It was great to be with you here today.